लास्ट ईयर प्रिलिम्स में प्रिजनर्स राइट से 2 क्वेश्चन पूछे थे. अब ये दोनों के दोनों पार्ट ऑफ अ राइट्स इशू सीरीज. नाउ मोस्ट ऑफ दीज बिग एमिनेंट इंस्टीट्यूट्स सेड दैट दीज 2 क्वेश्चंस वर डिफिकल्ट. ये अटेम्प्ट नहीं करने चाहिए थे, राइट? बट मैं आज आप लोगों को बताऊंगा कि हाउ इजी इट वाज टू अटेम्प्ट दीज 2 क्वेश्चंस इफ यू जस्ट न्यू बेसिक डेफिनेशंस. इधर हमारे अंडर ट्रायल्स की बात हो रही है, इधर कस्टडी की बात हो रही है, उधर पैरोल की बात हो रही है. एंड यही चीजें पूछ रहा है यूपीएससी. एंड ऑल यू हैव टू डू इज जस्ट अंडरस्टैंड द बेसिक डेफिनेशंस. So I welcome you in today's class where we're just going to look at basic definitions that will give you these marks. So let's start the class. अब when we're talking about rights of prisoners, it becomes very important as a topic. अभी तक हमको लग रहा था कि UPSC doesn't even look into rights issues per se. But here you have 2 questions in 2021, both from prisoners' rights. The first question was asked on judicial custody. ठीक है? And the second question was asked on parole. अब ये दोनों क्वेश्चन मैं अभी नहीं सॉल्व करूंगा, आप मेरे साथ सॉल्व करोगे once we are done looking at the key definitions. Now the first thing that we're going to look into is prisoner. ये prisoner कौन होता है? Now prisoner, it's a very basic definition, but you have to understand the 2 different parts of it. There are 2 types of prisoners. One who is an under trial, and the other who is a convict. अब अगर आप देखोगे, it's very clear from the name itself कि under trial कौन होगा? The person who is still under trial. अब क्या होता है when let's say the police catches someone through some information, through some report, through some first hand suo motu cognizance, उन्होंने किसी को पकड़ा, ठीक है? उसको लेके आए जज के पास. They produce him in front of a magistrate. अब magistrate now decides if this person based on the offense committed, ये non-cognizable offense है, cognizable offense है, bailable है, non-bailable है, that also we'll see. But based on this, the judge decides that इस person को judicial custody में रखा जाएगा या police custody में रखा जाएगा. अब while all these decisions are happening and while the case is going on, remember, when a police arrests someone until they are proven guilty, जब तक ये नहीं प्रूव किया जाता कोर्ट में कि ये लोग दोषी हैं, तब तक these are just suspects. And that's why this person is going to be called a person under trial, जिसका केस अभी भी चल रहा है, who has not been proven guilty. That person is known as an under trial person. Now the problem here becomes when we look at the statistics. हम अगर आप अपना जो NJDG का वेबसाइट है, the NJDG वेबसाइट, which is I think National Judicial Data Grid, National Judicial Data Grid के वेबसाइट पे जाओगे तो आपको you will get the live data, and the live data says that there are 4.7 crore cases pending. 4.7 crore cases pending in our Indian courts. About 70,000 of them are in the Supreme Court, about 58 lakh in the high courts, and 4.16 in the district and lower courts. Now, because of these pending cases, the number of under trial becomes very high. Like you must have read in the recent newspaper article from the Indian Express, which said that 76% of the people in jail right now are under trials. 76%, which basically comes down to, out of 4.8 lakh people, 3.7 lakh people are under trials, जिनका अभी भी केस चल रहा है. And remember, there are people here who are in prison for over 10 years, who are under trials for over 10 years, and this is about 36 lakh people who have been in jail for over 10 years being under trial, कि उनका केस अभी भी चल रहा है. Now, when the case comes to a conclusion, when the court decides that the person who was accused of committing a crime has committed a crime, upon looking into different evidences, upon coming to this conclusion, then the court gives him a punishment. At this point, once the crime has been proven, this person becomes a convict. He's been convicted by the court. कोर्ट ने बोला है कि इन्होंने ये क्राइम किया है, इनको अब पनिशमेंट दी जाएगी. That's the position where this person is known as a convict. Right? Now, let's understand what bail is. अब bail जो word है ये हमने हर जगह सुना है. This is one of the most prevalent words in criminal jurisprudence. But a lot of people don't know what the meaning of bail is. Bail एक तरीके का bond होता है जो एक person who is accused or who has been taken into custody signs with the magistrate. And in this bond, the person says that I will come before the court whenever the court summons me, and I give you a security in terms of money and surety. वो जो money देता है उसको bail bond कहते हैं, bail bond बोलते हैं, and जो surety होती है वो sureties are basically people who come with from the side of the accused, and these are the people who will make sure कि ये बंदा जब भी कोर्ट समन करे ये बंदा आए. The accused person arrives in front of the court, right? So bail is nothing but a bond that you sign with the court by telling them that मुझे जाने दीजिए, मुझे कस्टडी में मत रखिए आप, and आप जब भी मुझे बुलाएंगे मैं आऊँगा, and उसके हिसाब से मैं कोलैटरल आपको ये मनी देके जा रहा हूँ in terms of bail bond, and surety देके जा रहा हूँ. These people will make sure that I come and arrive in front of the court. Now that money is a refundable money. The money under bail bond is a refundable money. After taking some expenses of the court, the money is refunded once the whole case is settled. A bail bhi, there are types of bail. There is the regular bail, जो हम हमेशा सुनते हैं. Then there is the interim bail, and then there is the anticipatory bail. Now, a regular bail is what? Let's take a step back and understand. Bail, जो bail होता है उसमें भी दो टाइप के cases होते हैं. One is a bailable offense and another one is a non-bailable offense. Now, it comes hand in hand with the cognizable and non-cognizable offenses. तो मैं तुमको एक normal सा एक overview दे देता हूँ. Cognizable and non-cognizable क्या होता है? Cognizable offenses are offenses serious in nature, heinous in nature, जिसमें the police can make an arrest without a warrant and they can start an investigation without the permission of the court. That's a cognizable offense. Now, all cognizable offenses are non-bailable in nature. All cognizable offenses are non-bailable in nature. याद रखना ये चीज. And non-cognizable offenses are the opposite of it, where the police cannot make an arrest without a warrant and the police cannot do investigation without the permission of the court. Right? That's the non-cognizable offense. Cognizable offense usually serious crimes के लिए होता है, murder, rape, dowry deaths, and non-cognizable would be people making public nuisance, forgery, other sort of crimes which are non-serious in nature. ठीक है? In cognizable offenses, the punishment is really high. In non-cognizable offenses, the punishment is low. The threshold is usually 3 years. If it's punishable over 3 years, cognizable offenses, under 3 years, non-cognizable offenses. But none of this is hard and fast. Always remember that, because the discretion for all of this lies by the court. Ab, cognizable offenses are non-bailable in nature. Ab, if an offense is bailable in nature, us time pe, the bail becomes a right. In bailable offenses, bail is the right of the person accused. Us time pe, the police doesn't even need to present him in front of the court. The person can ask for bail as a right, कि मुझे, because it's a bailable offense. Also remember, when police is arresting someone without a warrant, the police needs to inform them कि ये जो offense के लिए हम आपको arrest कर रहे हैं, ये bailable है या non-bailable है. ठीक है? So in bailable offenses, the accused has a right to claim bail. Accused should be given bail, and in this case, the police themselves can give the bail. They don't need to produce him in front of the court. The police themselves will give them the bail. Right? Again, yaad rakhna, bail is just the bond. Bail is you signing a legal bond, giving some money, giving some surety if required, and then getting out of custody. Right? हम ये भी देखेंगे कि custody का मतलब क्या होता है. It's very important. Now, non-bailable में क्या होता है? The discretion lies with the court. The discretion lies with the court, where the court decides if the bail should be given to this person or not. There, the main discretion lies with the court, and in some cases, the police in charge of the station where this accused is arrested can give bail in very few cases. Again, these are some exceptions, and in that he has to present in writing why that bail was given. ठीक है? And ये सब depend करता है nature of crime पे. So usually all cognizable offenses are non-bailable in nature. In bail, if it's a bailable offense, the person can claim bail by right. In a non-bailable offense, the person cannot claim bail by right. In non-cognizable offense, the discretion lies with the court and the police, the officer in charge of the police station. In bail, there is no discretion. Bail मिलेगा तो मिलेगा बस. अब regular bail तो वो हो गया. Interim bail क्या होता है? Interim bail होता है when the bail hearing is going to happen, but is going to take time. So in that case, a person doesn't want to be kept into custody because that sort of messes the image of a person. अगर किसी को जेल में डाला जाए या किसी को कस्टडी में ले जाया जाए, that will affect the person's own image very immensely. उसके लिए क्या करते हैं? The person can approach the court by saying कि जब तक bail proceeding हो रही है, please grant me an interim bail so that I don't have to be in the jail while my bail hearing is happening. My regular bail hearing is happening. So that is interim bail. Then what is an anticipatory bail? Now anticipatory bail is taken even before the crime is committed. एंटिसिपेटरी बेल का जो कॉन्सेप्ट आया ही हमारे 1975 के जो हमारा जो इमरजेंसी एरा था उसके बाद आया है, वेयर a lot of people who were opposing the government thought that हमने opposition तो किया है, so these people might arrest us for cognizable offenses. They might put the people in power might get us arrested for cognizable offenses just to tamper with our own image. इसके लिए द पर्सन अप्रोचेस द कोर्ट एंड सेज कि मुझे एंटिसिपेटरी बेल दीजिए, जिससे कि कल अगर मुझे नॉन बेलेबल ऑफेंसेस या कॉग्निजेबल ऑफेंसेस के लिए भी अरेस्ट अगर किया जाए तो मुझे जेल ना जाना पड़े. एंड दिस वाज डन बिकॉज अ लॉट ऑफ फॉल्स केसेस वर बीइंग पुट अगेंस्ट अ लॉट ऑफ पीपल हु आर इन पावर और पीपल ऑफ इन्फ्लुएंस, एंड दैट्स व्हाई द होल कॉन्सेप्ट ऑफ एंटिसिपेटरी बेल हैज कम. नाउ द रीजन व्हाई बेल मैटर्स सो मच इज बिकॉज रिमेंबर in our jurisprudence and in international jurisprudence everywhere, the rule is that a person is innocent unless and until proven guilty, right? And then we've also said this many a times that bail is the right and jail is the exception. इन्हीं reasons की वजह से we have so many bail provisions. ठीक है? Cognizable, non-cognizable हमने देख लिया. Cognizable we saw that these are for heinous crimes. Non-cognizable are for crimes that are not so serious in nature. In cognizable, police can do arrest. They can do an arrest without warrant, and they can do investigation without court's permission. Right? Now let's look into custody. इसी के ऊपर क्वेश्चन आया था प्रीलिम्स में. Now custody, so once the police gets to know that a certain crime has been committed, they get an information, they get a report, they are in the incidence of the crime, they go ahead and arrest a person. When they arrest a person and get him to the police lockup, at this point the person is in police custody. इस टाइम पे the person is in police custody. During this time, our Constitution, Article 22, subclause 2 of the Constitution says that once a person has been taken into police custody, he needs to be put in front of a judicial magistrate within 24 hours, excluding the travelling time. So, once the person has been arrested and is presented in front of the judicial magistrate, now the judicial magistrate decides that if this person is going to stay in police custody or is going to go to judicial custody. Judicial custody means jail. Police custody means police ka thane ka lockup. Right? So the judicial magistrate will decide if this person will go to judicial custody, will he be sent to jail? When a person is sent to judicial custody, now he is in the hands of the court. The responsibility lies with the court. When the person is in police custody, the responsibility lies with the police. The biggest difference that you have to remember here is that when a person is in police custody, the police can conduct interrogations. Police can conduct interrogations without permission of the court. Without court's permission. When a person is in police custody, they can conduct interrogation of the suspect without any permission of the court. When a person is in judicial custody, when a person is in judicial custody, they cannot conduct any investigation. They cannot conduct any investigation or they cannot conduct any interrogation of the person unless until they take permission from the court. अब जो पुलिस कस्टडी है उसका मैक्सिमम ड्यूरेशन इज 15 days. इसीलिए आप देखोगे when a newspaper article comes out, they says that this person has been sent to a 14-day police remand or a 14-day police custody, because the maximum duration is 15 days, जिसमें वो जो 24 hours already added था in where the person was arrested. And the judicial custody has a maximum time of either 60 days for punishment which is less than 10 years and 90 days which has punishment to be granted over 10 years, right? Where the punishment is supposed to be granted over 10 years, it is 90 days, where the punishment is supposed to be below 10 years is 60 days. So, judicial custody, police custody. Now remember, a person can here come and claim bail based on वो bailable offence है, non-bailable offence है, क्या है. But बहुत सारे cases में क्या होता है, people are not able to furnish their own bail. People, especially poor people, they are not able to furnish because bail has a certain amount that is being decided by the court. Bail has certain conditions that is being decided by the court. तो बहुत बार क्या होता है, even though the court is granting you bail, even for bailable offences, if the court is granting you bail but you're not able to furnish a bail bond, आपके पास पैसे नहीं है bail bond देने के लिए, तब आपको judicial custody में ही रखा जाएगा. And यही होता है under trials के साथ. Either उनका केस पेंडिंग चल रहा है, either उनके पास पैसे नहीं है bail bond देने के लिए, या even after they have been granted, they are not able to fulfill certain different conditions being put by the bail bond. And इसी वजह से people stay under trial and they end up spending a lot of time in the court. Now इसके लिए भी court has put certain provisions where the court says that if a person under trial without even their bail hearing have spent half the period of their sentence, जो सेंटेंस उनको मिलता अगर वो अक्यूज्ड होते, तो अगर उन्होंने उसका हाफ भी टाइम स्पेंड कर लिया तो इन लोगों को बिना किसी ट्रायल के बेल दिया जाए. एंड इफ दे हैव स्पेंड द फुल पनिशमेंट विदाउट द ट्रायल बीइंग कंप्लीटेड, कि अगर उनको अक्यूज किया जाता तो उस अक्यूज के बाद जो पनिशमेंट मिलती है, अगर उन्होंने ऑलरेडी अंडर ट्रायल एज एन अंडर ट्रायल काट लिया है, इनको फ्रीडम दे दी जाए. सो द कोर्ट इज स्टिल ट्राइंग टू मेक श्योर दैट पीपल आर नॉट डिनाइड देयर ओन राइट टू लिबर्टी. Right? Now, let's look at parole and furlough. Now, parole and furlough are granted when a person has been convicted. अब once a person has been convicted, जब उनके क्राइम्स को प्रूव कर दिया गया है, कोर्ट ने उनको पनिशमेंट दे दी है और अब वो जेल में टाइम काट रहे हैं, अपना पनिशमेंट काट रहे हैं, उस टाइम पे they can avail these two provisions, parole and furlough. ये क्यों दिया जाता है? ये दोनों चीज़ों का देने का यही मतलब है कि the person should still be connected to their own personal life, to their own social life, and they should not miss out on some life-changing events or emergency events. Now, parole is granted for emergency cases. Emergency cases. For example, someone's death in one's family, marriage, सीरियस इलनेसेस, थिंग्स लाइक दैट, उसके लिए पैरोल दिया जाता है. अब जब पैरोल का कंडीशन आता है, ये कंडीशन द कोर्ट नीड्स अ प्रॉपर इमरजेंसी केस टू हैपन फॉर देम टू ग्रांट पैरोल. नंबर 1. नंबर 2, जब पैरोल ग्रांट किया जाता है तब पैरोल इज बेसिकली वो जब वंस दे आर सेंटेंस्ड दे गेट आउट ऑफ द जेल. पैरोल की वजह से वो लोग जेल, जब उनको पैरोल दी जाती है, वो जेल से कुछ टाइम के लिए निकल सकते हैं टू अटेंड दीज इमरजेंसी केसेस. अब पैरोल का मैक्सिमम ड्यूरेशन इज यूजुअली 1 month, एंड ड्यूरिंग दिस 1 month देयर सेंटेंस इज सस्पेंडेड. मतलब उनका जो टाइम जो चल रहा है, ये जो 1 month वो काट रहे हैं, वो उनके जो मेन पनिशमेंट है, अगर पनिशमेंट 3 years की है तो ये 1 month उससे हटा लिया जाएगा. तो ये 1 month उनके एक्स्ट्रा काटने पड़ेंगे बाद में. ठीक है. फर्लो में ये चीज नहीं होती है. पैरोल में डिस्क्रेशन होता है कोर्ट का, दैट द कोर्ट कैन डिसाइड इफ दे वांट टू ग्रांट द बेल और नॉट. राइट? इट इज नॉट अ मैटर ऑफ राइट. पैरोल इज नॉट अ मैटर ऑफ राइट. राइट? एंड इट इज यूजुअली ग्रांटेड ऑन अ पर्सन्स what the nature of the person is, what sort of behavior the person has had, ये सब देख के parole दिया जाता है. ठीक है. Furlough क्या होता है? Furlough is usually granted for long-term punishments. Parole is usually granted for short-term punishments. Furlough is usually granted for long-term punishment when a person has been in a prison for a very long time, and due to his good behavior, a person can be allowed to go out without any rhyme or reason, just as his own right, that I have been inside the prison, and to break the monotony of the prison, I want to go out, to stay in touch with my family, to stay in touch with my loved ones. उसके लिए furlough दिया जाता है. Furlough के लिए कोई reasons की, no reasons are required for furlough. No reasons are required for furlough. Now furlough again, because you don't have a reason, you take it as your own right कि हाँ मुझे अब मिलना चाहिए. But these are not legal rights. These are not given as a matter of fact कि आपको furlough आप मांगोगे तो कोर्ट को देना ही पड़ेगा. ऐसा नहीं है. Court there also has their own discretion. Court can allow, may not allow, right? And furlough is usually of 15 days. And during furlough, the punishment is remitted, which means that these 15 days are counted in your punishment days. In parole, the month or the time that you're outside jail is not counted in your sentence. In furlough, it is counted in your sentence. So even though you're outside for 15 days, that is still counted as you spending jail time. ठीक है? Very clear definitions. Also remember, prison, because we are talking about prisoners' rights, prison by itself is a state subject. So most of the rules that are being made are made by the state themselves. So ये जो parole के rule हैं, जो furlough के rule हैं, all these are made by the state themselves. Now that we know these definitions, let's just revisit the questions. हमारा पहला जो question पूछा गया था Prelims 2021 में, the first question was, with reference to India, consider the following statements. Judicial custody means an accused is in the custody of a concerned magistrate, and such accused is locked up in police station, not in jail. Very easy. We saw that judicial custody means that he is in the custody of the concerned magistrate, but he's in jail. Police custody is lockup. So this is wrong. During judicial custody, the police officer in charge of the case is not allowed to interrogate. Right? We saw that during judicial custody, the police officer is not allowed to interrogate, but during judicial custody, they are not allowed. During police custody, they are allowed. Very easy. During judicial custody, the police officer in charge of the case is not allowed to interrogate. Here, then, B becomes the right answer. Then similarly, with reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such a prisoner because it becomes a matter of his or her right. Does it become a matter of his or her right? No. The discretion always lies with the court, be it parole, be it furlough. The state governments have their own prisoners release on parole rules. Yes, because why? Prison itself is a state subject. Prison is a state subject. So, the first one is wrong, the second one is right, the right option becomes B. So, this is how easy it is. अगर हमको definitions पता है, simple definitions पता है, हम easily questions answer कर सकते हैं. And UPSC wants you to know these definitions. UPSC wants you to be aware of what is happening around you. ये words हम हमेशा हमारे न्यूज़ में देखते हैं, हमारे न्यूज़पेपर में पढ़ते हैं. UPSC just wants you to just look into it. And this is where I come in. I will give you these things. I will give you these definitions. You and me will get all of this done. Okay? So wish you all the best, and let's stick around for the next video where we actually talk about the rights the prisoners have.